What do you say we get going tonight? We get started. Couple things. Um, and I may have missed the slide when I was having a little technical problems, but we're giving away two of Scott's books tonight, The Trafficker. If you registered for the class at any time, you're entered to win. And at the end of the class, we'll pick two names, and if you get one, we'll send you one via FedEx, and you'll get a chance to read the crime story that Scott's going to be talking about. So we will be using the Q&A feature tonight. Scott has asked that he wants to go through his presentation before we ask questions, but feel free as you have a question to put it in the Q&A, which is just at the bottom of your screen, and go ahead and start the questions. And when Scott's done with his presentation, we'll go ahead and start asking him questions, and I'm sure you probably have a lot of them. So Scott's a retired law professor. He's currently the Declaration of Independence Center Scholar at the University of Mississippi's Declaration of Independence Center for the Study of American Freedom. He's a fellow at the National Association of Scholars and a columnist for Minding the Campus. He's a longtime member of the Ohio Advisory Committee to the U.S. Commission on Civil Rights. He has published 6 academic books, 49 articles, 38 book reviews, 136 op-eds, and 34 other pieces. He's published 5 novels, including most recently The Trafficker, which you'll hear a little bit about later. And he's made approximately 100 presentations, including at Harvard Law School, Princeton, Stanford, Columbia, University of Chicago Law School, University of Virginia Law School, University of Pennsylvania, Brown, I guess just really about everywhere. And he's a 5-time winner of the Fowler Harper Award for Excellence in Legal Scholarship, and he's a 3-time recipient in the Daniel S. Guy Award for Excellence in Legal Journalism. He also has received the Teaching Excellence Award and was named one of the top law professors in Ohio. We're just so lucky tonight to have Professor Scott Gerber with us. Scott, are you there?
Yes, I'm here.
We're glad to see you. Welcome to EmpowerU, and everyone is looking forward to your presentation. So before we turned on, Scott, you had expressed some interest in the Bengals. Now, I'm assuming since you're from Northern Ohio, you're probably a Bengals fan, though, right?
Well, I like the Bengals. I actually grew up in New England, so I'm a Patriots fan. You know how it works. When you're a kid, you glom onto a team and you never let them go. So I'm a Patriots guy, but I like the Bengals. I root for the Bengals. I root for the Browns, things like that, both of them.
Well, yeah, I was going to say at least you're not a Browns fan, but maybe a little bit. Well, listen, you're going to talk. You're going to start out. You're going to talk about the Declaration. I'm going to kind of turn it over to you, and everybody out there, as you have questions, put them in the queue, and a little bit later we will start firing questions at you, Scott. So, Scott, I'm going to turn it over to you. Welcome.
All right. Well, thank you. And I'm going to try to run my own PowerPoints. That's so if there's a glitch, it's on me. There's only 4 of them, so it shouldn't be too much of a problem. I would like to, of course, thank Dan and also Betty Overstreet for inviting me to participate in this evening's event. I previously spoke to this fine group on November 1st, 2023, and I enjoyed it very much. I also would like to thank the University of Mississippi's Declaration of Independence Center for the Study of American Freedom and the National Association of Scholars for their support of my work. As Dan mentioned, I will be discussing 2 topics with you tonight. The first is the Declaration of Independence. The second is my new Ohio-based legal thriller, The Trafficker. As you know, 2026 is the 250th anniversary of the Declaration of Independence. As you probably do not know, I write legal thrillers in addition to books about constitutional law and history. So now I'm going to try to activate my first PowerPoint. So wish me luck on this. Okay, hold on a second. I got to share the screen. It actually might be better, Dan, if you did it in hindsight, but let me try it.
Okay.
So yeah, can you take it?
I'll try. Just give me a second. I think I can do it.
So you got my slide? Yeah, you got them there.
Yeah. Okay. We're good.
Okay, so just the first one, just expand it, if you could.
Okay.
So- Or do I have to do that? Sorry.
You should be,
So there, can you see that? Is that working?
yeah, we're good.
Okay. All right. Well, anyway, okay, so we'll make do with that. Before I turn to my specific remarks about the Declaration, it might be helpful to mention that I'm a lawyer and a political scientist rather than a historian. I mention that because it affects how I approach the Declaration, as you'll see. My teaching and research employ texts and history to understand the political thought of American constitutionalism. The Declaration is central to my work. Relatedly, I should note that I became interested in the Declaration of Independence as a PhD student at the University of Virginia during a seminar on constitutional theory. Specifically, in the seminar, we read many of the classic works in constitutional interpretation, such as John Hart Ely's Democracy and Distrust, Robert Bork's The Tempting of America, and Ronald Dworkin's Law's Dominion, among others. I enjoyed reading the material, but I quickly came to realize that the theory of constitutional interpretation articulated in a particular book or article always seemed to lead to the political result favored by the author of the book or article. Bork's theory, for example, determined that Roe v. Wade was incorrect, whereas Dworkin's led to a generous use of racial preferences in higher education admissions decisions. What I set out to do in my seminar paper for the class was identify the appropriate political philosophy through which the Constitution should be interpreted. I quickly expanded my seminar paper into my PhD dissertation, and my revised PhD dissertation became my first book, To Secure These Rights, the Declaration of Independence, and Constitutional Interpretation. And so, Dan, could you pull up the second PowerPoint?
There you go.
It's still the first one, at least as I see it. Let me try it on my end real quick here. Let's see. Can you see that? It's the second. It's this one. This one here. Can you see it, Dan?
Yeah.
There you go. You got it. You got it. You got it. Okay. Okay. Thank you. My remarks tonight will draw from To Secure These Rights, and also from my book about Clarence Thomas's jurisprudence, which is sort of a sequel to Secure These Rights for the reasons I will mention soon. It might come as a surprise to some, but people disagree about what the Declaration of Independence means. For example, Gary Wills's best-selling 1978 book, Inventing America, argued that the Declaration embodied the communitarianism of Scottish moral philosophy, whereas Carl Becker's classic 1922 monograph, The Declaration of Independence, insisted that the Declaration was a Lockean liberal document committed to the privacy of individual rights. And to secure these rights, I agree with Becker. I would like to focus for a moment on a more recent interpretation of the Declaration of Independence, that of the Chief Justice of the United States. On December 31, 2025, Chief Justice John Roberts dedicated his annual year-end report on the state of the federal judiciary to the Declaration's 250th anniversary. There, he adopted the view of the late Supreme Court Justice Antonin Scalia that the Declaration, quote, consists of aspirations and philosophizing that do not lend themselves well to prescription or enforcement, close quote. In other words, the Chief Justice insists that the Declaration of Independence is not law. I respectfully disagree. After all, law, especially constitutional law, is more than words on a page. Here it is necessary to explain the connection between the founders' background attitudes on the purpose of government and the interpretation of the particular provisions of the Constitution. The most important point to recognize is that the Constitution was written for a reason, to establish a form of government that would provide better security for individual rights. Where did I go? Sorry about that. That would provide better security for individual rights than was provided under the Articles of Confederation. To make the point somewhat differently, the particular provisions of the Constitution were written with the founders' background attitudes in mind. The Constitution is not an end in itself. It is the means by which the American people's community's ideals, its ends, are ordered. It is therefore necessary to interpret the Constitution in light of those ideals expressed with unparalleled elegance by Thomas Jefferson and the Declaration of Independence. The necessity of keeping the founders' background attitudes in mind when interpreting the particular provisions of the Constitution becomes even more apparent when one realizes that many of the most significant provisions of the Constitution are phrased in general terms, especially those concerning individual rights. For example, the First Amendment's directive that Congress shall make no law abridging the freedom of speech is not unambiguous, nor is the Eighth Amendment's prohibition against cruel and unusual punishment. Moving beyond the original 10 Amendments, what does it mean to say, as the 14th Amendment does, that no state shall deny to any person the equal protection of the law? Provisions as general as these, and there are many others in the Constitution, are not self-interpreting. They can be given meaning in life only when they are construed in light of the moral and political principles upon which they are based. Although I reject the argument advanced by many proponents of the application of literary analysis to legal text, that meaning cannot be extracted from legal text, that can only be put into them, that in other words, the Constitution means nothing and means anything, it is difficult to deny the more modest claim that text can be only interpreted in some context, and that context is the political philosophy of the Declaration of Independence. Of course, it is possible to construe the provisions of the Constitution in light of philosophical principles other than those embodied in the Declaration. One need only peruse the plethora of provocative theories of constitutional interpretation advanced over the years to appreciate this fact. However, those advancing non-originalist approaches to constitutional interpretation have failed to show that the particular approach they favor is based on anything other than their own moral and political preferences. Indeed, the late Ronald Dworkin, a forceful critic of originalism, maintained that we should abandon the search, hopeless in his view, for the framers' intent in favor of the best argument about political morality. The problem with Dworkin's interpretive position, and a problem repeated by most lawyers attempting to articulate theories of constitutional interpretation, is that under his theory, substantive values are inevitably established by those with the best argumentation skills, by clever lawyers such as Dworkin himself. If the rule of law means anything, it surely means that the Constitution should not be interpreted in such a subjective fashion, especially by unelected and life-tenured judges. And Dan, if you could switch to the third PowerPoint, which is the Clarence Thomas, thank you. What I'd like to do now is move from the admittedly abstract discussion of constitutional theory that I just presented to a concrete example of applying the Declaration of Independence to specific legal dispute. My vehicle for doing that is U.S. Supreme Court Justice Clarence Thomas. Here is why I will be talking about Clarence Thomas at an event about the Declaration of Independence. I was writing my PhD dissertation about the relationship between the Declaration and the Constitution when Clarence Thomas was nominated to the U.S. Supreme Court. And that was a long time ago. The media was reporting at the time that Thomas was likewise interested in that relationship. I do not recall whether it was my idea or somebody else's, but given who Thomas was at the time, a judge on the second most significant court in the United States, and who he was likely to become, a justice on the most powerful court in the world, I put aside my dissertation for a couple of weeks and wrote an article to assess the degree to which the views on constitutional interpretation espoused in Thomas's speeches and writings and in its decisions on the U.S. Court of Appeals for the D.C. Circuit manifested the Lockean liberal commitment to individual rights that I believe the Declaration demanded. About 5 years later, after To Secure These Rights had been published and reviewed, my publisher encouraged me to write what became the first book-length exegesis on Justice Thomas's jurisprudence, First Principles, the Jurisprudence of Clarence Thomas, and that's what Dan put up on the screen. That's actually, as I recall it, the paperback edition, which includes new material, and I update that book through speeches and articles quite a lot. And my next book project is just to bring my Clarence Thomas book up to date. But the conclusions remain. And one of my conclusions in First Principles was that Justice Thomas is a liberal originalist, i.e. a Lockean libertarian originalist in civil rights cases, and a conservative originalist like Justice Scalia was in other areas of constitutional law. Thomas's liberal originalism, and I don't mean in the Ted Kennedy sense, so don't worry about that. I mean in the classical liberal sense, limited government to protect private rights. Thomas's liberal originalism traces to Thomas Jefferson, Abraham Lincoln, and Martin Luther King Jr. And it's an originalism that places the Declaration of Independence at the heart of the American conception of civil rights. When Jefferson wrote the Declaration during the summer of 1776, that's 250 years ago, he was inspired by the prevailing individual rights political theory of the day, most notably the political theory of 17th century British theorist John Locke. When Lincoln condemned slavery in the 1850s and 1860s, he was doing so on individual rights grounds. Slaves were people, Lincoln insisted, who were entitled to enjoy the rights of individuals, especially the right to be free. And when King delivered his famous I Have a Dream speech in 1963, and that speech is all about the Declaration, his dream was that his children would one day live in a nation, quote, where they will not be judged by the color of their skin, but by the content of their character, close quote. Clarence Thomas shares this vision of the American regime he has for most of his public life. For example, Thomas wrote in a 1987 article in the Howard Law Journal that the, quote, founding principles of equality and liberty set forth in the Declaration of Independence dictate the policy of action towards Black Americans, close quote. Thomas, who at the time was the chair of the U.S. Equal Employment Opportunity Commission, i.e. the EEOC, credited the first Justice John Marshall Harlan with being the initial member of the Supreme Court to appreciate the connection between the Declaration and the enforcement of the nation's civil rights laws. In particular, Thomas applauded Harlan's solitary dissent in the infamous 1896 case of Plessy versus Ferguson, the case in which the court constitutionalized the reprehensible practice of racial segregation. It was in that stinging dissent that Harlan coined the phrase that would later become closely associated with Thomas himself, quote, "Our Constitution is colorblind and neither knows nor tolerates classes among citizens." Thomas's critics strived during his 1991 Supreme Court confirmation process to mischaracterize his views about the Declaration of Independence. For example, Harvard Law School professor Lawrence Tribe wrote in a scathing New York Times op-ed that Thomas would use the Declaration to, quote, "turn back the clock to the darkest days of the nation's history." What critics such as Tribe failed to mention was that Thomas was articulating the standard individual rights interpretation of the Declaration, the same interpretation shared by Jefferson, Lincoln, and Reverend King. Thomas made this point repeatedly during his confirmation battle. For instance, when asked by Ohio's own senator at the time, Howard Metzenbaum, arguably Thomas's most unwavering opponent on the Judiciary Committee, about a speech Thomas had previously given, Thomas responded as follows, quote, "The point I think throughout these speeches is a notion that we should be careful about the relationship between the government and the individual, and should be careful that the government itself does not at some point displace or infringe on the rights of the individual. That is a concern, as I have noted here, that runs throughout my speeches." Close quote. Justice Thomas has continued to speak publicly about the Declaration of Independence since being confirmed to the Supreme Court more than 3 decades ago. For example, he reminded the faculty and students of James Madison University in Virginia that Madison, the chief architect of the Constitution, built the Constitution on, quote, "universal principles," which we find most succinctly and indeed elegantly stated by Madison's close friend, Thomas Jefferson, in our Declaration of Independence. Thomas went on in his speech to describe how the Constitution secures the rights promised to all Americans by the Declaration. In 1999, Justice Thomas delivered what, in my opinion, is the most significant speech about the Declaration of Independence since Reverend King's "I Have a Dream," the Lincoln Day address to the Claremont Institute. There, Justice Thomas urged the American people, quote, "to be ever vigilant in reminding us, me and everyone else, who has the privilege of serving our nation through public office, of the principles of our founding and how they apply to the controversies of our time." Close quote. Clarence Thomas is, of course, not alone in his commitment to the Declaration of Independence. However, what makes Thomas the most important voice today on the Declaration is the official position he occupies in the American regime, one of only 9 members of the nation's highest court. Thomas, in short, has the power to do something about effectuating the individual rights principles of the Declaration. His civil rights opinions and votes demonstrate that he has been more than willing to act on them during his tenure on the court. In 1995's Missouri versus Jenkins, for example, Justice Thomas became the first Supreme Court justice to directly criticize Brown v. Board of Education. Although he called state-mandated segregation, quote, despicable, he said that the court was wrong in 1954 to rely on disputable social science evidence to declare segregation unconstitutional rather than invoking the constitutional principle that, quote, the government must treat citizens as individuals and not as members of racial, ethnic, or religious groups. Justice Thomas's conception of civil rights as an individual, not a group concern, also explains his approach to voting rights, and there's been a lot of that in the news, voting rights. In 1994, in Holder versus Hall, Thomas wrote in a concurring opinion that racial groups should not, quote, be conceived of largely as political interest groups, that African Americans do not all think alike, and that existing case law should be overturned to eliminate claims for proportional allocation of political power according to race, close quote. Thomas has echoed these views in several more recent Voting Rights Act cases. With respect to racial preferences, the area of the law with which Justice Thomas is most closely associated, Thomas has issued numerous separate opinions on the court on that subject. In Adirondack Constructors versus Pena, the 1995 government contracting case that seemingly called the constitutionality of racial preferences into serious question, Thomas invoked the Declaration of Independence as the rule of decision. He wrote, quoting what Walter Isaacson has recently called, quote, the greatest sentence ever written, and this is Thomas now, quote, there can be no doubt that the paternalism that appears to lie at the heart of this affirmative action program is at war with the principle of inherent equality that underlies and infuses our Constitution. See the Declaration of Independence. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. So lawyers in the audience might have noticed that instead of citing a case to support his proposition, Justice Thomas cited and quoted the Declaration of Independence. So he thinks it's law, even though Chief Justice Roberts does not. Justice Thomas again invoked the Declaration in his 31-page separate opinion in the 2003 University of Michigan affirmative action case, Greta versus Bollinger, that was overruled a couple of years ago. So Thomas was proved correct. So here we go. After criticizing the Greta majority for, quote, failing to justify its decision by reference to any principle, Thomas closed his opinion by reminding his colleague that the controlling principle that articulated in the Declaration required the case to come out the other way. He wrote, and this is Thomas, quote, the majority has placed its imprimatur on a practice that can only weaken the principle of equality embodied in the Declaration of Independence and the Equal Protection Clause. It has been nearly 140 years since Frederick Douglass asked the intellectual ancestors of the law school to do nothing with us, and the nation adopted the 14th Amendment. Now we must wait another 25 years to see this principle of equality vindicated. I therefore respectfully dissent. As I just mentioned, he didn't have to wait 25 years. He had to wait 20, though, as you'll see in a second. In 2007, parents involved in Community Schools versus Seattle School District Number 1 Justice Thomas continued with this theme. And this is his opinion, quote, that it attempts to marginalize the notion of a colorblind constitution by consigning it to me and members of today's plurality. But I am quite comfortable in the company I keep. My view of the Constitution is Justice Harlan's view in Plessy. Quote, our Constitution is colorblind and neither knows nor tolerates classes among citizens. Next, and this shows how persistent he was, next, in a 20-page concurring opinion in 2013, Fisher versus the University of Texas, Justice Thomas equated the racial classifications embraced by the University of Texas with two of the Supreme Court's most reviled decisions, Karamazov versus the United States from 1944, in which the court permitted the internment of people with Japanese ancestry during World War II, and Plessy versus Ferguson from 1896, wherein the court endorsed the separate but equal doctrine, eventually rejected unanimously in 1954 by Brown v. Board of Education. Thomas's liberal originalist approach to civil rights law was in full sail when the court's then lone African-American justice reminded the state of Texas's flagship institution of higher education that, quote, the Equal Protection Clause guarantees every person the right to be treated equally by the state without regard to race. At the heart of this guarantee lies the principle that government must treat citizens as individuals and not as members of racial, ethnic, or religious groups, close quote. And it is because of the Equal Protection Clause guarantee of every American's constitutional right to be treated as an individual that, Justice Thomas insisted, the nation's highest court, quote, must subject all racial classification to the strictest of scrutiny. Under strict scrutiny, all racial classifications are categorically prohibited unless they are necessary to further a compelling government interest. Unfortunately for the University of Texas, Thomas continued as follows. The educational benefits flowing from student body diversity, assuming they exist, hardly qualify as a compelling state interest. Indeed, the argument that educational benefits justify racial discrimination was advanced in support of racial segregation in the 1950s, but emphatically rejected by this court. And just as the alleged educational benefits of segregation were insufficient to justify racial discrimination then, see Brown v. Board, the alleged educational benefits of diversity cannot justify racial discrimination today. Okay, and here we go. Most recently, Justice Thomas wrote in a concurring opinion in the Supreme Court's 2023 consolidated decision in the Harvard and the University of North Carolina cases, holding that colleges and universities cannot consider race in admissions decisions that, quote, while I am painfully aware of the social and economic ravages which have befallen my race and all who suffer discrimination, I hold out enduring hope that this country will live up to its principles so clearly enunciated in the Declaration of Independence and the Constitution of the United States, that all men are created equal, are equal citizens, and must be treated equally before the law. And I'd like to mention one other case before I turn to my novel. And that's a case out of Ohio that the U.S. Supreme Court decided in 2025. And that case has largely fallen under the radar. But as I wrote in an op-ed for Fox News at the time, that case has, quote, killed DEI. And that case is Ames versus Ohio Department of Youth Services. And it was a unanimous decision. Indeed, one of the most liberal members of the court, Justice Ketanji Brown Jackson, wrote in the opinion for the unanimous court that the, quote, background circumstances rule at issue in the case, imposed by several lower courts of appeal, requiring members of a majority group to satisfy a heightened evidentiary standard prevail on a Title VII discrimination claim, is inconsistent with the text of Title VII and the Supreme Court's anti-discrimination precedent. Justice Jackson's opinion reversing the lower courts might as well have been penned by Justice Thomas himself. She quoted the text of Title VII that makes it illegal to take an adverse employment action against, quote, any individual. She further quoted a 2020 Supreme Court decision, Bostick versus Clayton County, that held that, quote, the law's focus on individuals rather than groups is anything but academic. She added, by establishing the same protections for every individual without regard to that individual's membership in a minority or majority group, Congress left no room for courts to impose special requirements on majority plaintiffs alone, close quote. Justice Thomas joined Justice Jackson's opinion for the court in full, but he also issued a concurring opinion in which he suggested that the background circumstances rule is not only inconsistent with the statutory text of Title VII, but is, quote, plainly at odds with the Constitution's guarantee of equal protection. Most important for present purposes, Thomas made clear that if proponents of DEI are hoping that the Ames decision has nothing to do with their DEI program, they are sorely mistaken. Quote, this is Thomas, American employers have long been obsessed with diversity, equity, and inclusion initiatives and affirmative action plans. Initiatives of this kind have often led to overt discrimination against those perceived to be in the majority, close quote. And in closing my discussion about the Declaration, I'd like to mention that when Justice Antonin Scalia died in 2016, court watchers openly speculated about who would replace him as the intellectual leader of the conservative legal movement. Clarence Thomas has unquestionably filled that void. After all, in Ames, even Justice Thomas's liberal colleagues on the nation's highest court conceded that American law protects individual rather than group right. For Justice Thomas, that is what the Declaration of Independence means. And so, Dan, if you'd now put up PowerPoint 4, the cover of my novel. And so now, for the remainder of my talk tonight, and it won't be too much more, I'd like to talk about my new Ohio-based legal thriller, The Trafficker. The Trafficker is available in hardback, paperback, and ebook. The audiobook will be available soon. And so here is the précis from the dust jacket. So this is a summary of the book. When a 14-year-old girl is discovered by an off-duty police officer at a truck stop outside of Toledo, Ohio, she won't reveal her name, what she's doing, or where she's from. A concerned juvenile court judge appoints acclaimed law professor Cameron Warren as the girl's guardian ad litem and asks the professor to try to find out more about the girl so the court can return the girl to her home. What the professor learns along the way shakes him and the legal system designed to protect our children to the core. The Trafficker is a rocket-paced legal thriller that provides heartbreaking insight into one of the most serious problems of our time. So what I'm going to do now is just read a couple of scenes from the novel, and then I'll close by explaining why I wrote a legal thriller about human trafficking in the first place. And so here's the opening scene involving the main character, a law professor named Cameron Warren. 14. Cameron Warren shifted his gaze to the police officer who was bringing him up to speed on the most recent victim. Went missing at 12, the police officer continued. Cameron returned his attention to the young woman. Child was more accurate. She was wearing tattered jeans, a cheap pair of canvas sneakers, and a green t-shirt that matched her eyes. She had long auburn hair and looked as if she hadn't eaten or slept in weeks. Cameron asked, "What's her name?" The clock on the wall read 3:28 a.m. The police officer answered, "She wouldn't say. Other than telling me her age and how long she's been away from home, she wouldn't say anything about anything. But as you know all too well, Professor, that's not unusual in this sort of thing." The officer took a sip of stale coffee. Cameron nodded at the officer. He studied the child through the two-way mirror. The officer had provided the child with a soft drink and a packet of peanut butter nab. She drank the soda, but the crackers remained untouched. The officer said, "The emergency hearing with Judge Kaminsky is in half an hour. You gonna be there?" Cameron raked his hands through his graying hair. "Of course I'll be there. That gives me just enough time to call my wife." Next is a scene later in the novel involving the antagonist, the trafficker, in other words, and he's a middle-aged man, and so here's that. The middle-aged man rapped on Tweedledum and Tweedledee's bedroom door. He didn't wait to be invited in. Why should he? It was his house, and they were his girls. He owned them. He had convinced himself. He owned all his girls. The bedroom looked like a hurricane had struck. Clothes were scattered everywhere. None of the furniture was positioned in its original spot, and dirty cotton balls, bottle caps, and spoons littered the floor. The two 13-year-old girls, his girls, were lying naked on the disheveled bed. The prettier of the two, Tweedledee, was scratching her twig-skinny arms. The other girl, Tweedledum, was fumbling for a syringe so she could inject another hit of junk. Obviously, Tweedledum and Tweedledee weren't the girls' real name. But the middle-aged man rarely knew the real names of the girls who worked for him. Almost all of the girls were runaways who declined to provide their real names. Frankly, he didn't want to know their real name. The petite girl with long auburn hair had never told the middle-aged man what her real name was. Tweedledum and Tweedledee occasionally called her Catherine, but he wasn't sure whether that was actually her name. It didn't really matter, though. At least it didn't matter to the middle-aged man. It wasn't like he was planning to submit a T4 slip on her behalf. The middle-aged man found the syringe and handed it to Tweedledum, who held it in her teeth while she proceeded to tighten the shoelace around her forearm to make a vein pop out. He said, "I've got a question for you." Tweedledee watched while Tweedledum held a lighter underneath a bottle cap containing heroin powder. Tweedledee started to cook the heroin into liquid for injection. "Save me some," Tweedledee said to Tweedledum. Tweedledee turned to the middle-aged man. She was still naked, but wasn't self-conscious about it. "What's your question?" she asked. "Did either of you help Catherine escape?" Tweedledee turned whiter than she already was, and that was saying something about a girl of apparent Irish descent who spent almost every hour of every day inside the house on a bed. She said, "No." The middle-aged man didn't believe her. "Are you sure?" He grinned and lit a cigarette. "Don't worry, I'm not mad." But it was obvious that, even stoned on heroin, Tweedledee could tell that the middle-aged man was mad. Tweedledum was too busy cooking the heroin to realize that a question had been posed. Silence filled the bedroom. A dog barked in a neighbor's yard. The middle-aged man grabbed Tweedledee by the jaw and brought his face to within inches of her. "I forgot how young she is," he said to himself. He released his grip and exited the bedroom. And what I'm going to do now is talk about why, and this will only take a couple minutes, why I wrote a novel about human trafficking, of all things. So the novel was published in mid-January of this year, which was National Human Trafficking Prevention Month. I explained in an op-ed published in several Ohio newspapers at the time why I wrote a legal thriller about human trafficking. I titled the op-ed "The Hidden World of Human Trafficking in Ohio," and here's what I said. And then I'll take questions. Every year since 2010, the President of the United States has dedicated January as National Human Trafficking Prevention Month. In 2015, the Ohio Advisory Committee to the U.S. Commission on Civil Rights, on which I serve, issued a report on human trafficking in Ohio. The testimony of one particular human trafficking victim has haunted me ever since. Indeed, her heart-wrenching account touched me so deeply that I felt compelled to write a novel about the god-awful subject. That novel is The Trafficker, and it was published this week. I chose to write a novel, a legal thriller in terms of genre, rather than an academic book about human trafficking, because I strongly believe that fiction can often educate in a more compelling fashion than nonfiction. To Kill a Mockingbird is the classic example of how fiction can teach. In the incisive words of historian Joseph Crespino, quote, "In the 20th century, To Kill a Mockingbird is probably the most widely read book dealing with race in America, and its main character, Atticus Finch, the most enduring fictional image of racial heroism." Although I'm neither foolish enough nor arrogant enough to suggest that The Trafficker is a 21st century To Kill a Mockingbird, like Harper Lee before me, I wanted to reach people at an emotional level to wake them up. In my case, about the horrors of the hidden world of human trafficking. The novel is not graphic in the physical sense of that word, but it is upsetting, as unfortunately it has to be. The novel is set primarily in Toledo, Ohio, a city that I was shocked to learn during the Ohio Advisory Committee's investigation is a hub for human trafficking. The story is told from three alternating points of view: that of Cameron Warren, a law professor appointed by a court to serve as the trafficked girl's guardian ad litem; that of Jane Doe, the traumatized teen victim who refuses to reveal her name; and the middle-aged man, the anonymous trafficker after whom the novel is named. Cameron Warren is a happily married man with 3 wonderful children, has dedicated his life to eradicating human trafficking. He went so far in his professional life as to draft and help get enacted into law a federal statute punishing human trafficking. In his personal life, he frequently volunteers as a court-appointed guardian ad litem to try to save one child at a time. Jane Doe has grown up in an abusive family environment, as many trafficking victims have, and that has led to a series of terrible choices from which she is trying to extricate herself. She does not trust anyone, including Cameron Warren, who has more than earned her trust. Every legal thriller needs an antagonist, and the middle-aged man serves that role in The Trafficker. He is driven by money, as most traffickers are, especially the large sums of money that some depraved people are willing to pay for the so-called premium product, a 13 or 14-year-old girl. Although The Trafficker is a work of fiction, it's based in fact. The Ohio Advisory Committee to the U.S. Commission on Civil Rights report on human trafficking, information provided by anti-trafficking groups and law enforcement officials, and material I discovered when researching the book, like a January 2024 Rolling Stone article on the subject that a friend sent me. Does the novel have a happy ending? I will leave it to readers to find out for themselves. In the meantime, I hope as many people as possible will take national human trafficking prevention to heart and help end what the lawyer who chaired the Ohio Advisory Committee called, quote, an insidious scourge unfolding inside seemingly ordinary homes and neighborhoods. And so with that, I want to thank you for your attention, and I'm happy to take questions about either the Declaration of Independence or my novel, The Trafficker.
I'll tell you, Scott, you brought up some bad memories when you brought up Howard Metzenbaum's name. That took me way back. Let's take some questions. I've got a question from Richard, and he asked, was Abraham Lincoln's metaphor of an apple of gold in pictures of silver referring to the Declaration's second paragraph?
Absolutely. Absolutely. And as Walter Isaacson said, the sentence that we all know from grammar school, the greatest sentence ever written.
Well, that was straightforward. Thank you. Tom asked the question, is it true that an early oh, by the way, anybody who's got a question, now's the time, go to the Q&A at the bottom of the screen and give us your questions, please. Tom asked the question, is it true that in an early draft of the Declaration of Independence that the phrase life, liberty, and property, and with property was changed later to the pursuit of happiness? What does that mean, and how should that affect it? How should that affect us today?
Yeah, very good question. Yes, that's true. Jefferson was a great writer, so pursuit of happiness sounds better than just property. And in Locke's theory, property included not just real estate or the pen in your hand, Dan. It included, all parts of our lives.
What is your expectation on Justice Thomas and when he will retire?
I don't know. I mean, I don't think he's going to retire. He's close to setting the record, the longevity record, and he'll stay for that. I think it's only about 2 years away. He'll stay for that. People are saying that he or Alito should retire before President Trump leaves, so the president can appoint another conservative. But I don't think he'll do that. Alito might do it, but Thomas won't.
And you talk about Thomas as being a liberal originalist with respect to civil rights, but a conservative in other areas. How would you compare, let's say, Alito and Kavanaugh with Thomas in those perspectives?
Yeah, Alito's more just a straightforward conservative. What I mean by liberal originalism is what we call libertarian.
Right.
And so Thomas is a libertarian on civil rights, but he's more of a traditional Robert Bork, Antonin Scalia conservative. What did the founders understood this phrase to mean, rather than what does this principle of equality mean as applied to a specific case? And so in terms of Kavanaugh, I think he's more just an old-fashioned moderate Republican like they'd have up in New Hampshire back in the day.
You talked quite a bit about DEI, and I loved you talking about this case of Ames versus the Ohio Department of Youth Services. My question is, if something happens and things change, and we go to another kind of administration, do you think DEI bounces back, or has enough of a dent been placed in it?
Yeah, I think it'll bounce back as a policy from the administration. But the courts, I think, if it ever gets to the Supreme Court, will end it. I mean, you can see that in, for example, Virginia. And I went to Virginia, and so I've been following that a lot. Their president that was pushed out when the DOJ came in to investigate, he was the king of DEI, and so the board voted to eliminate it. But now that a Democrat, the governor, Abigail Spanberger, they're putting it back in, and it's really sad. So there's a practical example.
Now, will federal law stop that?
Yeah, it will, but it takes forever, and people drag their feet. They lie about it. They're doing it all the time. It still goes on, even in Ohio, where you can't do it. These Ohio colleges and universities, they're still doing it. They're still doing it.
So many people in Ohio are so worried about what the kids are learning. Can you give us an assessment of what you think, let's just take high schoolers, what their take and understanding of the Declaration of Independence is?
Yeah. Brian Thomas asked me that on the radio today. My sense of it is that they don't know much more about it than the day that we separated from Great Britain. And it's just, as Chief Justice Roberts argued, symbolic. They don't understand the moral principles articulated in it that Justice Thomas, for example, is trying to implement into law, that Abraham Lincoln understood were at the heart of the American constitutional system, and so forth.
So I just applaud you on your passion for the trafficker. And I think one of the things about human trafficking, we hear about it a lot, but it's hard for some of us to kind of understand where you see it at. Where do people look to see this problem at, to get their hands around it?
Yeah, no, I mentioned that to Brian this morning, and also to Bob France about a month ago. I venture to say that all of us, every one of us, every other week or so, encounters someone that's being trafficked, and we just don't know it. And they're at the hotel next to McDonald's. A lot of the trafficking goes on in people's private houses, right? That kind of thing. And so we just don't know it. And that's why in 2010, the president, and it's happened ever since, has dedicated January to National Human Trafficking Prevention Month. He wants people to learn about it. And recently, about 3 months ago, I was on the train to D.C., and I just noticed, because I'm hypervigilant now, there was a little plaque in the bathroom that literally said, if you're being trafficked, do this, right? So tipping off a victim who had, was alone for 5 minutes because he or she had to go to the bathroom, what to do. And then during our hearing, we also learned that some groups were putting that kind of information on the soap in these budget motels. So these kids, when they were washing their hands, could see what they should do to escape their situation.
With respect to the Declaration of Independence, what did Jefferson get wrong?
What did he get wrong? Well, they should have been, and I get the argument, he put in a condemnation of slavery. He put it in, and Adams and Franklin said, take it out because it will never be approved if you leave it in. But he should have stuck to his guns on that. Lincoln bailed him out by saying that the country wasn't strong enough to get rid of that. We first had to become a united country, and then once we're strong enough, we'll get rid of slavery. And Lincoln said, that now's the time, and I'm going to do it. So that's, of course, the biggest one. And he was a hypocrite personally, obviously. He himself had slaves. So
Right.
he freed his own slaves, for God's sake.
Like George Washington, right?
Yeah, right. Yeah.
Now, what about, did Jefferson help much? Did he help Madison much on the Constitution?
On the Bill of Rights, he did. Jefferson was in France, but he'd write to him and talk about the Bill of Rights and how important that was. And so they were correspondents, So yes, he helped them indirectly.
So, living your life, what are you going to do to celebrate the 250th birthday of our nation?
Well, I give talks like this. I'm given several of them, and when July 4th comes around, I'm gonna eat plenty of hot dogs and watch fireworks. That's for sure. Our country isn't perfect, but it's pretty good.
It is great.
Good.
It's not good. It's great. Scott, so good to catch back up with you. It's been a couple years, and just thrilled about your new project. We're going to give a few books away in a couple minutes. Thank you so much tonight for joining EmpowerU. Have a great night, Scott.
Thank you,
Professor
Dan.
Scott
Thanks
Gerber.
for having me.
Thank you.